Hey guys, welcome back to my channel. Welcome back to Real Talk Bougie, guys. We're going to get into this Sarah Boone hearing. This was on the 14th. I watched the whole thing. It's weird because it wasn't, I don't know if it was being broadcast live actually, because there was so much going on Wednesday. We were in court with old Susan. But as soon as we got out of court with Susan, Court TV actually still had it on like the Court TV website, and I had to go into Court TV app, and I was watching it in the app, and then they premiered it on YouTube. But I don't know. I haven't spent any other time looking on any other outlets as to who has it posted. But at the end of the day, it was good. Okay. Let me see if anyone else has this thing posted because but Core TV is pretty cool. I mean, it is what it is. I hope everyone is having an awesome Sunday. We were just live and covered some things. If you are in Patreon, I have the I have some of the things posted. I posted the Apollo Nida arrest warrant. I posted the information about Julian Morris, and some links to the Ski Boys, the official Ski Boys Instagram, and some information and links to the sister, the angry sister, who's, I mean, I get it. Look, she has her feelings, and she gave a whole entire speech as to why and all of that. If you don't know what I'm talking about, go to the video I just posted. We had a nice live, about 2 hours. We covered mucho hot topics, and I think we had a good time. It was fun. So I hope that you guys will get into it. Right now, we are getting ready to go. We're back in court. Okay. Court is back in session, and Susan is doing the most. Susan has been sitting in the Orange County detention center for women, which is in Orlando. Sis is accused of second-degree murder in the homicide of Mr. Jorge George Torres. He died of, what was it called? Something asphyxiation due to being in a suitcase. And Sarah was pissy drunk and taunted him as he was gasping and begging. He kept saying, Sarah, Sarah, I can't breathe. I mean, sad, very sad. Any of the videos that you've seen on this internet where somebody is gasping for breath, begging for air, all of the things. George gave us all of that. And this nincompoop weirdo who was pissy ass drunk, who I think is a miserable ass drunk, um, because there are a array of drunk body worn camera videos um, of the police going to the Winter Park, maybe it's the Winter Park area, going to Miss Sarah's apartment, having to deal with the shenanigans of this couple. And they were warned by a police officer. He said, we have to separate you guys for the night because sometimes these things end in death. He said, I'm just trying to tell you, like, these things don't end good. I mean, it was really sad. Like, one of the last times that the police came out to see them prior to his death, one of the police officers actually said oftentimes this ends up in someone dying. And these police officers see this stuff every single day. The police are not trying to break up relationships. They are trying to help. You call them for help, and they're there to help, and they're telling you what they see, no strings attached, every day around the city. And the man told George specifically, because he said, you want me to call you Jorge? He said, no, you can call me George. He said, everybody calls me George. And George seemed like such a nice guy. And I think he really liked Sarah, but Sarah was a bitch. And you know how some men love a bitchy female? And I think that that's her. Okay. Um, yes, one of the last, thank you for bubbling that up. One of the last interactions they had, and as well as if you see in, I think we covered this in the last hearing we talked about, when the head of security for the courtroom said that he considered Sarah to be a risk and certain things they would not want to allow her to do because of her history. One of which was one of the last interactions, like maybe let's say February of the year that George died, let's say 2020. Um, there was an incident where she had her hands wrapped around his neck. Now, he may have kicked her or pushed her, so it was on both of them, but they had a tumultuous relationship, and another one of these couples that's how they do business. They tussle, they fight, they argue, they cuss each other out. I think they had gone across the street to the bar to have some drinks. They were both drunk. George I think he left the bar, maybe went outside to smoke a cigarette or whatever he went to do. He went outside, came back in. Sarah had asked for a cigarette from someone else, and George got pissed because she was talking to some guy at the bar or whatever, and of course, argument ensued, and all of the things. Police were called later that day. So just drama. This is a couple with a history of drama. But George didn't. I mean, she basically tricked him, in my opinion. She set him up for the okey doke. And we also know that there was a situation with her son. She was doing something a mom should never do. And she did some more shenanigans with a suitcase and her son. And people called CPS on her, and it became a CPS case. So Sarah has a history. Her husband doesn't have anything nice to say about her. Sarah is somebody who nobody really has anything nice to say about her, and she's documentedly quite difficult. Okay. If you don't know anything about Sarah Boone, all you got to do is Google. All you have to do is hit the search bar. And then also you can hit my playlist of videos that we've done on the Sarah Boone topic thus far. Um, and that's really it. I mean, I could never begin to tell you all of what there is to know about this woman, um, even that's public, to do it justice in like a little snippet. But let's get into the hearing. It was quite interesting from a procedural standpoint because number one, she's pro se, which means she's defending herself. Why is she defending herself? Because she has exhausted her use of the public defender system. She has been assigned numerous lawyers, and for many different reasons, most of which I would say fall onto her, she has ran people off for many different reasons. Everything is not her fault. Most are her fault. Okay. So, based on that, the judge has said that she has chanced out with the public defenders. The state of Florida no longer feels compelled to help pay her lawyer fees anymore, and she's going to have to do it herself. They're no longer, she can have an attorney, but the state of Florida said they are no longer paying for it. Okay. So that's a different thing. They're not denying her legal. They said, if you want it, you can pay for it. We're not paying for it anymore. We've paid for it enough. Nothing is ever good enough for you. And we're not wasting any more money. We're not going to take any more delays. We're not going to deal with your shenanigans anymore, since you seem to want to do this, and these professionals have also recommended that you would be able to do fine by yourself, and based on the fact that nothing is good enough for you, then that very well may be the solution, because it's almost impossible to defend this woman. So the only person that can really help Sarah at this point is Sarah. Okay. So we'll start from there. Okay. Um, let's get into it. Sis is over here in court. This is a pre-trial hearing. Sis has been filing motions. She has won a few motions. She has earned extra time to have her laptop to do her pre-trial trial research to help develop her case. She has a private investigator who had already been hired and budgeted by her previous lawyer. So that was kind of grandfathered in. She has won the ability to have not only digital, but her hard copies. She also has been offered a opportunity to have some privacy, but it will be in the form of, I guess, I don't want to say solitary confinement, but they would be putting her in a troubled person dorm where pretty much I think it is solitary confinement, if you will, ish. Okay. But then she can have the privacy she wants. She requested a classroom. They were like, no. Okay. So we're going to hear some of this because she actually wrote a letter to the Department of Corrections, and Department of Corrections came with their lawyer, and they were very professional. They went through the whole thing, but damn it, the Department of Corrections lawyer was like, "Look, enough already. Like, what is the damn deal? Sis is out of control." I'm paraphrasing, but basically that's what the attorney said. Let's get into it without further ado. If you have any questions, you guys talk to each other. I'll break in here and there. You know how I do. And let's talk about it. So here she is. This is something that was settled in the last, I'll let her walk in before they won't be talking for a minute. So this is something that was settled in the last hearing. Sarah had been in the jury box untethered, right? So she requested to be able to sit at the desk. She doesn't have her shackles on. They're taking her shackles off. She still has leg restraints, but she is permitted to sit at the desk and have her equipment, her I don't think she has her laptop yet, but she has her pen and paper folder, things of that nature. She has her security. Um, and she's, it's important that if you are on trial that you have a fair opportunity. You are innocent until proven guilty, and they are giving her the dignity to be able to defend herself, not in shackles and cuffs. Okay. So here we go. It's going to get started in just a moment. The sound quality is much better. They're swearing her in. This is the setup. That's the clerk right there. There's judge, and that's his judicial assistant right there. So if you go to Orange County website, you will see the judicial assistant. That's ma'am right there off to the judge's side. He's so patient. I really like this judge. I feel like he's really good. Um, if the speed permits, I will increase the speed. But let me just get a feel for how fast everyone or how slow everyone is talking to see what I need to adjust it to. A snack and a meal. Hey, everybody, welcome, welcome, welcome. I didn't say hi to everybody. How rude of me. Welcome, welcome, welcome. Thank you for coming through, Bougie Gang. Happy Sunday, guys. Um, love you guys. Me, Jackson Tabasco, Leo Lady. 1, 2, 3, first. Welcome, welcome, welcome. Bougie Gang, welcome. Happy Sunday, guys. Feel free to put some Sundays in the chat, put some judges in the chat. Okay. Because we are judging on today, girl. We will be judging and we will be talking, and you can put some shades too, because I'm sure the shade will be flowing. Okay. Sarah is asking for everything. Okay. Everything but the kitchen sink. Sarah, nobody can help you now, sis. Only person that can help you is yourself. And nobody feels bad for you either. I hope the judge had a good lunch before this meeting. I think he did. He was very patient. He handles her. He handles her very well. Okay, this
to address the factors under the case.
Okay, this person right here coming up, they were kind of a little bit late putting the audio up. I think this person right here is for the people, and the people as I mean the media. Sarah wanted to have a private session regarding her physical evidence that's being shared by the prosecution. And the news media, local news media channel came and said, no. So they filed a motion. The judge heard it. Um, and this is what happened. That's what's going on right now. Just a second. He didn't put the sound on. Come on, Judge.
My intention for this afternoon is to have Ms. Boone proceed first with anything that she'd like to tell me. I will hear from the state if they have any position on the matter, and then I'll hear from you, and then the court may be in a position to make a ruling at that time.
Thank you,
Okay?
Your Honor.
Yes, ma'am.
Have a seat back there.
Or wherever you feel most comfortable.
I can just sit back there while she,
Okay, thank you.
until I'm ready here.
Thank you, ma'am. All right, Ms. Boone, you can proceed, ma'am.
First and foremost, I do not know what it is that you are referring to.
When you say you do not know what I'm referring to, what do you mean?
Motions were filed by the WFTV and the Orlando Sentinel.
Yes, ma'am. So there was a motion to intervene for the limited purposes of opposing closure that was filed on August 12th by WFTV. It was sent to you by U.S. mail at the correct inmate legal mail address on August the 12th. And the Orlando Sentinel's motion to intervene and notice of joinder was filed on August 13th. And it reflects, it said the certificate of service was August 13th, and it was sent to you at the same legal mail correspondence address.
So Sarah, I'm not going to say Sarah likes to play dumb, but she likes to play dumb. That's number one. Number two, in the last hearing, she requested that the news media be excluded and get some privacy for her evidentiary hearing. So the judge entered that in as a motion, like a verbal motion. And she's like, I didn't know I was entering a motion. I would have sat and done a proper motion. Had I known that was a motion, I didn't know that that was what I was doing. So nobody really told me. And I didn't really understand that that was the reason why that I was here. And I'm not prepared. I'm not prepared to argue this. And like wait till y'all see this. She's a mess.
Address at the Orange County Jail. Have you received either of those motions?
I have not.
Okay, I have copies. Oh, perfect. All right.
And I do apologize on the Sentinel one, but the e-portal was down for a little while, so I love the attempted to file it yesterday because it actually got filed.
That's why I was saying it. The certificate of service reflects the 13th, but the filing information is of this morning. All right, Ms. Fugate has, I am pronouncing your name correctly, am I not?
Yes, you did.
Thank you. Ms. Fugate has provided copies of those motions. So Ms. Boone, if you'd like to take a look at those, feel free to take your time to review them. And then after you've reviewed them, I may have the opportunity to answer any questions you have about them if I can, and then we can proceed.
Your Honor, there were also some circuit court cases that I know are in the report that might be hard to find. I have extra copies of those if anybody wants them.
If you want to provide those to Ms. Boone as well, you can do so. Thank you. State, do you need a copy of them?
Thank you.
All right, thank you, sir.
If I may say, Your Honor,
Yes, ma'am.
one of my topics of discussion, as you know, are the requests in regards to the laptop and internet being one of the most important. Would I have had access to that, I would have already had this and not had to sit here unprepared. I believe that is a major violation to my due process of me not having these in advance to prepare properly and to utilize the court's time and everyone else's here by me having to do this now. So I wanted to put that out to you that I am unprepared for this. I did not know that I had a statement to prepare, as everyone else did also prior to being here.
Ma'am, you were provided the case law as you had requested at our last hearing. It was mailed to you. You asked for the case law that the court was making reference to. You specifically asked for it. That was provided to you. It was mailed to you.
Case law?
Yes, ma'am.
What was the date that it was mailed?
August 9. What was provided to you on August 9 was the additional copy of the pro se packet as provided by the Justice Administrative Commission. You were provided a hard copy of that in court, along with the case law that was referenced at the August 9 hearing that the court had said that it had reviewed in anticipation of the hearing that we were having this afternoon.
I don't have that. The only thing that I was provided was the notice of provision of witness list from the state, and then the JAC packet.
Those were both provided to you in court. You are correct. The balance of the things that I'm speaking about were mailed to you at the legal mail address on August 9.
Which I have yet to receive.
Okay.
Now, the JAC packet, if any of you guys are following this and you are not going to Orange County Clerk to check some of these things out, you have like full access to this. You don't even have to get a sign on. I requested a sign on just because there's some stuff you can't see without having a sign on. But you have to like go get it. No, I had to print it out. I got to go get it notarized at the UPS store. But there's a lot of stuff that you can see without having a sign on, like just from the public viewpoint. And that JAC packet is in there. I'll click through it. I'll pull it up for you guys and show you some of the things. But basically the JAC packet gives you kind of like, it's like a user manual for pro se defendants. And basically they give you kind of the blueprint and like all the instructions that you need. They give you some ready to use forms. They tell you what can be paid for. They give you all different kinds of things to help you as a pro se defendant. And she knows she's got a ton of stuff to look at. And look, as far as I'm concerned, I'm going to tell you guys this too. The sheriff's department submitted her tracker, basically kind of like her chain of custody of when she signs out her computer and signs it back in. Sis is not even, you would think the way she behaves in court, she would be standing waiting for her computer at 7:59. Sis isn't signing out the computer till 8:15. They've let her have it later than she was even supposed to have it. Like she's all over the place. So she's willfully obstinate. Thank you very much. She is very defiant. And she's so angry. But I'd be angry too if I did something stupid like kill my boyfriend and have to sit the last damn 4 years in jail. Like that was dumb. What you did was dumb, and you are prolonging the punishment. Like you may as well just get with the punishment and get it over with, because there's nobody that came in, snuck in, and did what happened. That was all you, sis. Okay.
Okay. Ma'am, with regard to
This is the first time I'm seeing each one of these documents.
I understand that. They were filed August 12th, and unfortunately this morning due to an issue with the e-portal.
I wouldn't have internet access anyway to receive those.
They were sent to you via US mail as well.
Yesterday?
Yes. So you're not wasting the court's time. You can feel free to review those at this time.
What are these? Is this the case law you're referring to? State versus Smith?
I believe that those are the circuit court opinions that are referenced in WFTV's motion, which cite to the Miami Herald versus Lewis decision, which is the controlling law on this matter.
All of these are yours. And these are mine to take? Thank you.
Yeah, so to your point, Sanders, they actually handed her a copy of everything as she left, but I think she's so bogged down with paper. And she's also really worried a little bit not about the right things. Like she's worried about certain things that really shouldn't be at the forefront of her attention. And she's not digging into even just sorting out like her evidence and even like her mail. Like right now, you have a case to prepare for, and you also have hearings to prepare for, which could all sound like the same thing, but they're not, because you have all these pretrial motions and you are trying to get the tools and everything necessary to fight your case, but you're worried about can you have a classroom? Or people seeing, or can I have headphones, or can I do this, can I do that, and just a lot of things that are not necessarily at the forefront when you have like 60 days to fight for your life. You know what I mean? She's probably like, I can't make heads or tails of this stuff. Like, what in the world have I got myself into?
I'm ready whenever the court is. There's only so much that I can do just now receiving these. Have any opportunity?
She low key complains. I'm ready. There's only but so much I can do. Not being prepared and blah, 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 and nobody gave me this and nobody told me and I didn't realize and da 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 and you didn't tell me and I can't be expected to know. I don't really want to defend myself and da 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 da. She is really waiting for an open door to find a judicial error or mistake that she can be able to leverage to an open door in the future. Because I don't think that she's the only way that Sarah Boone is going to be walking the streets of Orlando is on a technicality, and the judge is not playing with her. He's playing the long game, and he's very, very, very patient and respectful with her, but she is really trying everybody's patience.
Opportunity to look up any case law of my own in the meantime, so.
You can proceed, ma'am. What is it that you'd like to tell me?
He's like,
about
I don't
your
care.
Concerns regarding the September 3rd evidence viewing that's been previously scheduled.
My concerns is regarding my case and the whatever is left evidence that is not already on the internet or posted anywhere on social media. And I'm wondering what the reasons for the court other than sensationalism and exploitation. The purpose would be for them to watch me look at the remaining bit of my evidence that has not been globalized. again, my main concern is it is for exploitation purposes, which has already been greatly applied to my case in many, many ways globally again. And I see on the motion to intervene for WFTVs, my question is, why is this an important criminal proceeding? I don't. And why do they need to have it?
You're a female accused accused of second degree murder in a high profile case, and you are a pro se defendant. Why is it high profile? Because the public wants what the public wants. The public has an interest in this case, and it is a public building. You are sitting at a desk that the people of Florida paid for, and the people want to know. And we have a right to be able to see these proceedings because it has been alleged that you took a man's life who you didn't have the permission to do that either. So that's why we want to see, because that's what our system is made. Like, sis, you don't know that? You think you deserve privacy? Girl, bye.
Monitored. I don't understand the reasons why just for this one. I'm not asking for all of my other hearings to be closed. Simply, this is my one and only. It is my right to have some kind of privacy regarding my case. Nonetheless, it is an active case. It is my understanding that some information is not able to be publicized due to privacy. And it's not their right to pry and exaggerate, which is the whole point of why they want to be included in this one and only most important hearing that I would say that I have on the horizon. The press doesn't have a right to press themselves into everything in regards to my active criminal case.
The press doesn't have a right to press themselves. Like, sis, her vocabulary is very limited. She speaks slowly because she's really trying to sound smart. And she does have some arguments some of the times, but she has a very limited vocabulary. And you'll notice that she uses some words inappropriately, but it's like the overly verbose. For me, it's like, sis, come on, spit it out.
And I feel that from this, one meeting should be closed to the press so I can rightfully, lawfully do what I need to do in order to properly, rightfully, and lawfully defend myself. At this point, I feel that there's nothing even suppressible in my case that is not already on the internet and have been spread all on the internet. I'm trying to salvage whatever it is that I can possibly to have a card to play at least one in the end during my trial. I do not feel that it is right lawfully to have them included in this hearing, this one hearing, and I am asking for their minutes to be closed.
Okay.
This is an active, ongoing investigation and case.
Anything else, ma'am?
No, Your Honor.
State, do you have any position on Ms. Boone's closure motion?
No, Your Honor.
All right. Ms. Fugate?
Thank you, Your Honor. I think Ms. Boone's argument really flips the question. It's not why the media wants to be there. What transpires in the courtrooms, even pretrial hearings, is public property, and there's a right to be there. I'm not going to go over the Lewis test because I know Your Honor knows it well, but it's a very strict standard, and it's the plaintiff's burden to meet. I haven't seen a case in Florida where a criminal case was closed on a defendant's privacy concerns. We're not talking about third-party privacy concerns or something that's not inherent in the proceeding. This is the evidence. And even with respect to the evidence and it being still an active case, Florida law is clear that once discovery is provided to the defendant and accessible to the defendant, that becomes public record. That too becomes open to the public. So with respect to the first part of the analysis, I don't think the defendant has established that this hearing needs to be closed to protect her fair trial rights. Publicity isn't necessarily synonymous with prejudice. She has to show widespread, adverse, hostile publicity, and then specifically show why that publicity is going to be aggravated by access to the September 3rd hearing. The discovery in this case has been public. I'm not sure what specifically would be aggravated by access to the hearing. So I don't think she's met that first burden under Lewis. And importantly, the admissibility of evidence, Ms. Boone said she didn't think there was anything suppressible, but even if there was, courts often suppress evidence but still allow access to the hearings and the evidence themselves. That's fairly routine. That alone, just the potential admissibility, that alone is not a sufficient reason under Lewis to close a hearing. And as your honor is aware, there's plenty of alternatives under the second factor to protect the defendant's fair trial rights. Careful questioning and jury selection can protect against publicity. The courts of this circuit have had their fair share and are well familiar with high-profile cases, and they are well equipped to insulate and protect juries from even prejudicial publicity. And finally, any closure would have to be effective and broader than necessary. Again, I'm not sure why the hearing would need to be closed, but I think even Ms. Boone has indicated it would be ineffective with what's already out there. And that was a consideration under Lewis. If the information is out there, the discovery in this case has been public, there's no reason to close a hearing that's simply going to discuss things that have already been made public. I think heightened public attention only increases the need for transparency. Closure of judicial proceedings is a drastic remedy, and I don't believe the plaintiff has met her burden in this case, Your Honor.
Okay.
Unless you have any other questions.
I do not.
Thank you, Your Honor.
All right. Any closing remarks from you, Ms. Boone?
Yes, Your Honor. First, I'm only asking for this one hearing, which is a very important hearing. I believe that the press is simply in it for ratings and publicity. My evidence is active. And
Can I just say, so it's always that argument, even like on YouTube, they're only in it for clicks and views. Do you think the average person makes a video because they don't want someone clicking and watching the content that they create? You think the news company is just out here with reporters and attorneys and collecting news and information because they don't want to keep the public informed? I mean, it's the dumbest argument ever by somebody bothered by people talking their tea, their news, the whatever. A news station is there to distribute news. They're not just there to archive. They're not a library. They're not an archivist. They are a news outlet that is informing the public of relevant information in the community that matters to them. Like it's like, Sarah, your argument is stupid. Like, you should really be sitting there and thinking about what you're saying. There is no reason, like, you're not giving any good reason as to why the news shouldn't deliver the news. Like, come on.
I'm trying to salvage the little bit of anything that I have pertaining to my evidence that is not available online, which would be in that hearing. And I also heard she was speaking in regards to once discovery has been received, it is therefore a public record. I just received my discovery for the first time, and I'm still reviewing most, if not all of it. And I have not had the time to go through all of it, but I literally, on the record, just received my discovery to even have an opportunity to prepare to review any of that. And in regards to the hostile publicity, I have letters, I have messages, I have tablet information. I have an entire folder dedicated to publicity in more than one way as being hostile, good, bad, ugly. It's publicity. This will incredibly enhance my inopportunity to have a fair trial because of the already millions of viewers that I have in my case, literally in my case. This would just contribute to it even greater. I'm not asking for all hearings to be closed. I've not had an opportunity to review my discovery, which I just received. I have an entire folder and more information and letters and evidence in regards to publicity, hostile, any type of emotion that you can come up with. I have received from Australia being the most recent. So I do not believe just because they would like to, again, in my opinion, for ratings and for publicity, it's one hearing. There also is a solution that I believe, my understanding was that this could be held at the Orange County Sheriff's Department. The question was in regards to transport, which is a possibility. It was a matter of the decision being with the court. I would like to be able to properly prepare for this. Would I have received everything prior as everyone else did? Having the internet would have helped also in regards to receiving the notice via email, as everyone else had. I'm sitting in front of you, yes, unhandcuffed, but I am unprepared for this rebuttal in regards for me to have privacy, expected privacy to a certain degree, and by law, to have this one hearing closed. And that we also have an active case that is ongoing, active evidence, and there's a solution for it to be held at the Orange County Sheriff's Department as well.
Anything else from the state?
I wasn't going to bring it up until after the ruling on the motion, but the parties have reached an agreement to do this on our own. And as soon as that gets accomplished, if it's accomplished to both of our satisfaction, then I'll let the court know so you can free up the hearing time.
Okay, we'll address that momentarily. Ms. Fugate, anything else? All right. Under the Miami Herald versus Lewis case, ma'am, Ms. Boone, you had the burden of producing evidence and proving by greater weight of the evidence that closure is necessary. What has been presented today has failed to meet that burden. Your motion to close the September 3rd viewing is denied. The court will follow up with a written.
I'm sorry, but I'm going to give a big look, let me just say this. So Sarah has been doing really well in court, I'm going to say. She has had a few motions, and her motions have, hey, boo, hey, gossip, rumor, and innuendo, guys. I love gossip, rumor, and innuendo. She's a Jersey girl, just like me. If you are into true crime, sis drops videos Monday through Friday, early in the morning, and she's a doll. So go say hi to Kathy on me. That's a gossip, rumor, and innuendo. Thank you, boo. Thank you for supporting, sis. I appreciate you so much. Sarah has been winning some motions. And I think, I'm not going to say I think she thought she was going to skate, but I think she has been kind of like, ooh, I won. Like, kind of like, you remember in Legally Blonde, and Elle Woods was kind of like, well, is this supposed to be hard? I think Sarah lucked up and got some wins early, and I'm not sure what she thought, but the judge is not playing with her anymore. Like, it's not going to be easy wins anymore.
And delivered today. Ms. Fugate, if you don't have no longer any business before this court, you are free to go, ma'am. Thank you. Have a pleasant afternoon. Mr. J. Yes, ma'am.
Forgive me.
Sarah talks very repetitively, so no, it's not your imagination. She has a limited vocabulary. That's my opinion on that. I think she is searching for, she realizes, okay, so Sarah's the type of person in the presence of people that maybe she feels like are more educated, more important, any of those things, because I think she battles with low self-esteem for many different reasons. I think she tries to step up to the occasion. There's no way she can't, you know what I'm saying? She's not stupid, but she's not an well-educated woman. And I think she feels intimidated by her situation. And I feel like she is searching for the words. She's searching to sound smart and intelligent, and that she can keep up with these people. She seems to like wordplay and debate and all of those things. And she can't, these people are not playing with her. This is a legal proceeding. No one's playing with you. This is not George, any of those things. So she is going to repeat herself, because I don't think it's like that she's trying to stress a point more than she doesn't have the words. She doesn't have the vocabulary, and she is out of her league at this moment. So it's forcing her to step up. So she's very repetitive. Yes. Unnecessary fillers. Thank you.
When you stated to the court that my motion was oral, was this during the last hearing that we had?
It's like, sis, he's already denied you. Move on.
Requested this both, ma'am, on August 5 and on August 9.
What was it specifically that I requested?
You had requested privacy with regard to the September 3rd hearing. And I advised you that I needed to look at the law on it. And you asked again on September 9th when we were going to address it. I said that we would address it on the 14th. You asked for copies of the law, and those were mailed to you on the 9th.
Which I have yet to receive. And I was not instructed by anyone in the court, including yourself, that that was an oral motion. If I needed to actually do a proper motion, I would have correctly done so.
That's why we had the hearing now, because you asked for it orally. So you orally moved, or tenaciously moved, to have that motion heard. And we set it up for today, since we already had the hearing time carved out to address you receiving the hard copies, which seemingly has already been remedied. And last week when we had our hearing on the 9th, I said, I don't want to lose that hearing time because we already had it carved out. So we would proceed with the hearing on the privacy issue at that point in time. You then asked for the case law. I said, absolutely, I will get it to you. Mr. J had advised that he was familiar.
If you watch the last hearing, he literally handed it to her, and they prepare minutes from every court proceeding that is published on the website that I'm sure Mr. Lane, her investigator, she could probably ask Mr. Lane, hey, every time we go to a hearing, can you please print that off for me and have it for me the next time that we meet up? Like, you have a resource. You have a resource. Use it. So they provide minutes from every single meeting, all of the motions, all of the responses, like everything, like you and I can get it. So if you and I can get it, she can definitely get it, right?
With the case law. But regardless, it was provided to all parties and mailed to you on the 9th.
which I have yet to receive, and I was not instructed by anyone in the court.
On top of everything, guys, it's all free. It's all free. Some places you got to pay for every document you get. Florida, it is free.
That was an oral motion for me requesting privacy. I thought it was just a comment that I could have on record.
Ma'am,
I don't need to do anything further.
that's why we set the hearing, because it was something that you had asked for. And that's clear in the order that was provided to you on the 9th as well. It says that we would have a hearing today on the 14th.
And when did I receive this?
Well, that
He
was
handed
orally
it to
told
you.
on the 9th. The letter itself was mailed to you on the 9th.
She's so busy worried about, am I going to have shackles on when the jury comes in? She's so worried about the wrong thing. They literally made the decision. And as court was finishing for the day, he went back and kind of surmised everything that was discussed. Like, okay, we're going to do this, 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 and this. And she's not paying attention.
Right? But the order itself was read to you during the course of that hearing. Specifically on August 14th, 2024 at 1:30 p.m., a hearing will be held in courtroom 12A, Orange County Courthouse, 425 North Orange Avenue, Orlando, Florida 32801, regarding defendant's review of the USB drug tribe, which contains the state digital evidence, the defendant's August 7th letter to the court, delivered to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. That was all addressed with you, ma'am, on August 9 here in open court.
In the order I have yet to receive.
But it was read to you, ma'am. It was read to you as to what we would be doing today, and that we would addressing the issue regarding the media's participation. And that's when you asked for the case law. And I said, I will give it to you. Absolutely. And it was all mailed to you on the 9th.
And she may not know this, guys, and we've seen this like in YSL, you can submit a motion and the judge has ruled on it, but you can resubmit the motion again. She could say, I would like to be heard on that motion again. The judge could still say, I deny it. He might entertain it. At the end of the day, you had the burden of proof. It's not the submitting of the motion. She's not listening. It's not the submission of the motion. It's the submission of evidence and case law to support your argument. And she's not listening. That's where like the rubber meets the road. She is a very defiant woman, and she's so in her head, she cannot hear the feedback. And that's why she's in the position that she's in right now, because he's basically telling her what she needs to do. She could resubmit the motion, but she won't, because she's missing the clues as to and observing what's going on in the courtroom to see how the courtroom actually works. It's denied, but you can resubmit it. You can ask to be heard on it again and have some more information. But no, she wants to make the judge wrong and try to make it a technical error, which she's not going to catch this judge on that.
I'm not ever sure of what it is that I'm supposed to be doing with.
You see how she couldn't make the judge guilty. So now I'm not really sure that I know what I'm supposed to be doing. Feel sorry for me.
I guess now oral and also in writing. And again, I'm sitting here waiting empty-handed for everything that was mailed to me day before yesterday and or could have been readily available on the internet, which I do not have access to. So I'm guessing that your verbalization of the order that you read to me, which I have not received, is supposed to suffice.
Ma'am, you were told about the hearing in open court on Friday
August 9th?
If I knew to be prepared, I know that everyone knows that I would be prepared, which I am unprepared because of.
That's certainly your opinion that you're entitled to. Any reason for Ms. Fugate to remain? State. Okay.
From the state.
All right. Ms. Boone, any reason why counselor for the Orlando Sentinel and WFTV should remain?
No.
Okay. Thank you, ma'am. All right. In addition to what was set to be addressed today, which was the Ms. Boone's review of the USB jump drive, which contained the state's digital evidence, Ms. Boone's August 7th letter regarding her requests from the Orange County Jail. Mr. J, you made reference to a potential change in the September 3rd meeting. I want to hear about that, sir.
I believe we have reached an alternative solution to an evidence view with the defendant. And as soon as that is accomplished to both parties' satisfaction, then I will notify the JA so that we can release your hearing time.
Okay.
I know it's valuable.
Can you explain to me what the proposed plan is for the viewing?
There will be a time and place where the evidence will be brought, the defendant will be brought, and she will be given as much opportunity to experience an evidence viewing like a defense attorney as possible. Her investigator will be there and allowed to take photographs and ask if he wants any particular bag of evidence opened so that it can be photographed, inspected, tested, copied as provided by 3220 in the criminal procedure rules. And then the evidence will be brought back to where it's stored, and then the defendant will be brought back to the Orange County.
Okay. Have you had a conversation with Ms. Boone prior to today regarding this proposal?
Well, with Mr. Lane, who has indicated her position, which was that she agreed to that.
Okay. All right. Ma'am, I don't want to go into specifics of what you've had with your investigator, but has he relayed to you what Mr. J just advised the court of?
Yes, to a certain degree, it has not been fully explained because it is in the process of being spoken about between the two of them. So yes, I do know that that is a solution to my request.
Okay. And did you understand what Mr. J advised the court of today regarding how that process for you viewing the physical evidence would be?
If you could please do so again.
Sure. If you could explain it again for Ms. Boone, Mr. J.
You see what I'm talking about? She needs medication. I don't know if she's on medication or not, but she might need some Adderall or something like that. She's so caught up in her fucked up attitude. She's she's not listening. You got to, like, you're basically in like a mental tennis match right now, and you need to listen to what's going on. She's so busy, pissed that the man just said it for 3 minutes, what he could offer, what could be worked out, rather than a open court view of all of this evidence. They could do it in the sheriff's department with security, have your investigator take pictures, all of the things. Basically, even though the judge ruled against her, the state is willing to have more of a sheriff's department. So maybe the press would still be there, but it wouldn't be an open court. So maybe the press could take pictures and be there somewhat, but it's not going to be kind of the setup that we see right now. And basically, even though you lost the last motion because she's pissed about that, they're offering an alternative type of setup to the view examination. And she's so busy not listening. So the judge asks her, and she doesn't even know what the hell they talked about. She said, "Could you repeat it again?" What were you doing?
When the defense attorney wants to do an evidence view, we typically go to where the evidence is stored, depending on the law enforcement agency. He or she can bring.
You see how he has to talk to her
And investigator is able to take photographs.
like she's his neighbor?
Requested. We typically don't let the defense attorney manipulate the evidence from her for herself. The CSI, who would be present as well, who is the crime scene investigator from the law enforcement agency, would be the person to manipulate the evidence on the cutting paper. And then we would have the opportunity to review, test, inspect each piece of evidence. So for instance, I'm not saying this is the evidence, but a piece of clothing, with the front, with the back, you have the CSI turn it inside out, those sorts of things. And then it's documented by the investigator with photography. Between each piece of evidence, there's a new piece of cutting paper, butcher paper laid down so that there's no contamination for DNA testing. And this is basically how the process goes on with the If it gets opened, it'll get resealed by the CSI right there in front of all of us, and the CSI will reseal the tape, re-put his or her initials over it with the new date, so everybody will be on the same page about why it was opened, when it was opened, so on.
Thank you for that. If I may, is it closed or is it open to?
No. People that are not involved in the case will not be there.
And if I may, if you know, will my phone physically be there?
If it is stored in physical evidence, then it can be brought over. We're not going to be turning it on. If it needs to be photographed or examined, it can be photographed and physically examined. But in order for it to be turned on, it would have to be done at a different location, where there's something called a Faraday box, or a room where electronic signals cannot come in or out.
Do I need to write a motion for that?
For what? For your phone to be brought over and turned on?
She's so dumb. She says, do I need to file a motion for that? If your dumbass would listen, he says, I have a compromise that might work well for the state and the defendant. Hear it like she's not listening, guys. Like, to me, she's just not listening. So now she's all motion crazy because she's figured out how to file a motion, and she has gone motion bananas and thinks, do I need to file a motion for that? No, dummy. You're in the hearing right now. You're actually in it. You already filed the motion. The motion was filed and just argued and denied, but the state is offering a change of venue, which would change the setup. So no, there doesn't need to be a change in motion. There basically the press still has a right to be there. That has not changed. But if the state changes the venue, then it'll change the setup for the press. The press will still be invited, I'm sure, but it'll be different. It'll just be different. Okay? Guys, it's like she needs an interpreter.
If I can extract any type of information from it.
So, like we discussed at the last hearing, that would be up to you to hire a digital forensic examiner, and then we would make arrangements with that person so that he or she could image the phone in the same manner that it was imaged by one.
Thank you, and grateful.
Okay. All right. Then, ma'am, after having Mr. J explain that alternative solution to the evidence viewing, is that something that you would like to participate in?
Absolutely.
Okay. So then, is it the parties' agreement to no longer have the evidence viewing here in open court on September 3?
That's the state's position, but again, been doing this long enough to know that you can never predict every possible hiccup. But I will defer to the court if you want to free up your hearing time now, or wait until we're able to tell you that we're satisfied.
Okay. Ms. Boone, are you in agreement with that alternative solution?
At the Orange County Sheriff's Department?
Wherever the viewing is going to take place. I don't know that a specific location was identified, but yes, where it's going to take place.
I am.
Okay. So then here's what we'll do. I will keep the hearing for now. The deadline to have that viewing as set forth in the August 5 scheduling order and notice of hearing will remain of September 3. If that evidence viewing takes place at a law enforcement agency based on the protocol as identified by Mr. J, I'll just need a notice that's provided, signed by Ms. Boone, signed by the state, signed by Investigator Lane, as to when it took place and how long the viewing was. And if that's provided to me, we'll then cancel the September 3rd hearing.
Yes, sir, we'll do that, and we can even list physical items that were brought and viewed.
My only question about that is we had sealed at the last hearing the witness list and the exhibit list.
I think all the property receipts and all those sorts of things are already in the public record.
Okay.
I think there's a vast difference between a list of evidence that's already in the public record versus having them look at it with television cameras.
Okay. All right. Fine. Ma'am, are you amenable to that additional procedure that after the evidence viewing takes place, you would sign a notice reflecting when and how long that evidence viewing was?
Of course.
Okay. And then once that's provided to the court, it can be filed, and then the court will cancel the September 3rd hearing. Yes, ma'am.
And that is done by the state?
The state will prepare it.
Documents and bring them.
Yes, ma'am. The state will prepare it. All you need to do is just review it and sign it.
Thank you.
Okay.
It's like, that's his evidence. You have your evidence. You have your discovery. I just wonder. So guys, think about this. So she got all of her discovery from Miss Cashman, right? I don't know. And it's possible that Investigator Lane furnished the state with an identical thumb drive of the evidence and gave it to them as kind of the reciprocal on her discovery, right? But I wonder if she understands that she needs to submit, like the state needs her discovery, that what Miss Cashman had doesn't mean that that's what the state has. And what the state is doing right now is sharing their discovery with you as you are to share your discovery with them. I haven't heard that, but I feel like but they gave her that in that guideline, that 150-page guideline that she was mailed the other day. It's up to her to read it. If she doesn't follow procedure, she's going to have problems.
All right, thank you, Mr. J, for providing an alternative solution. Ma'am, I wanted to go back and address your request for the freedom of movement motion that we addressed last week and your desire to use a stun cuff. I understand that a representative from the public defender's office spoke to you about clothing and what they may be able to provide to you. Is there any preference with regard to clothing that you may have?
As opposed to a skirt and pants?
Correct.
Yes, I very much would prefer to wear a skirt.
Okay. So if you wear a skirt, as explained to you by Officer Barnett, the stun cuff is located on your calf Achilles area. It would be something that would be viewable by the jury. So do you understand that if you choose to wear a skirt for clothing purposes, that's going to be viewable by the jury?
I understand. My belief by you asking me was that maybe it could be moved to a higher place where it cannot be seen, or is it strictly to the one area?
As Mr. Barnett or Officer Barnett explained at the last hearing, how the stun cuff is affixed to a person, it is on the lower leg ankle area.
Okay. I'm not understanding why this is being asked.
Because I want to bring it to your attention that if you have a desire to wear clothing which would reveal the stun cuff, I want you to understand that it's something that the jury can and may be able to see.
I understand. Is it a decision I need to make today?
It's something that you need to consider.
I have.
If you're wearing pants, they obviously cannot see it. If you're wearing a
I'm going to be honest with you, Glorious. I don't think she's playing dumb. She's not smart. I think some people give her a little bit more credit. Sis, I don't know what her level of education is, but she's not like dumb as a doornail, but she's hit her ceiling of her critical thinking and her deductive reasoning. Sis, there's just a certain point when you realize I'm out of my league a little bit. And it's not to say that it's formal education that seals that for most people. Some people are very bright and can figure things out. I think she's making her way through this process, but she doesn't get it all together. She doesn't. She's not super duper smart. She is more cunning and sly, and she's more with the trickery foolishness than she is someone who is figuring things out because she has some sensibilities. It's due to her lack of sensibilities that she's in the position that she's in. I don't think she's playing dumb. She really is. She's dingy. She's dingy for lack of a better word. And I think she's stuck in her own way. So things that are being talked about, it's going right over her head because she's stuck on the last thing that didn't go her way. And she's like literally having a temper tantrum in her mind. I think she does have a very childish mentality, and it's holding her back from this proceeding to be able to hear. It's very important that she's listening to what's going on. And I think she takes a break every now and again in her mind. She might have some ADD that's not being treated. I don't know, but she probably could use some Adderall right now. If she's not taking it, if she is not ADHD, I don't know who is, but she really is.
skirt, they can see it. And you're making a intelligent, knowing decision that they can see that.
And it's not ADHD, it's due to her lack of intelligence, because we all know that that's not the case. But I think it's a combination of her inability to focus along with her defiant spirit, and her reaching the ceiling of her intelligence is holding her back. She doesn't understand.
And that you want to proceed with wearing a skirt. your other option.
So the argument right now, you as a defendant, even if you are confined, you have a right to show up in court and not look like you've just spent 3 years in jail. That's why you see YSL dressed in their own clothes. You don't see them in shackles. The shackles are not visible to the jury because they really should not know whether they're spending their nights in jail or they are free, right? And someone being in jail could give prejudice to the jury that, oh, you've been in jail all this time, or they feel like, I guess there are reasons and around the fact that a person who is in the process of their trial, they have the right to kind of show up in their regular street clothes and all of those things. So if you see a shock, it's not a shock, it's like a shock cuff. So it's some sort of a restraint that could be used. So if someone decides to try to break her out of jail or break her out of the courtroom, or she decides to go get missing or whatever the case might be, they can immediately press the button and it will stop her. It's like a taser. It's basically almost like a taser attached to her leg. And she's not understanding that it will be visible. And as long as you're okay with that, then we're okay with that. But we not want you to understand that if you want to have some sort of degree of the jury not taking that in as like, oh, what's that on her leg? Oh, she has a shock thing. Oh, she needs to be restrained. Maybe she's a violent person. All of those things that people can make assumptions about. If he's saying, if that's okay for you, then that's okay for us. And she's like, I don't understand why you're asking me about my clothing.
Option, if you do not like either of those, is the parties will remain, you'll be hands-free, as we discussed, but you'll have the leg restraints like you have today. And everyone will conduct everything from counsel's table. All direct examinations and cross-examinations, any questioning of any witnesses, any argument, any opening remarks or closing arguments or opening statements will be made from counsel's table. You can certainly stand, but we will not have the opportunity to walk around the courtroom. Now, I know that we talked about in our last hearing that we would have another hearing when we have our trial case management in September, addressing the box as to where everybody would go to. And last week on the 9th, I said that we would limit access from counsel's table to the podium, and we wouldn't be allowed to approach a witness or the jury. And those same restrictions would be placed on the state as well. I'm not telling you what to do. I'm just giving you a series of options. Because if you want to wear a skirt, you have to understand that the jury can and will be able to see that device that's affixed to your leg.
And by my hearings that we have spoken about the stun cuff, they are televised, correct?
To the best of my knowledge, the media has participated in the majority, if not all, of the hearings that this court has had with you.
Does the court broadcast live, or is it uploaded to the clerk of the court's website?
It's like, sis, what? She's so worried about the internet. Like, literally, this is another interesting aspect. If you're new to this case, sis is so bothered by YouTube and the internet talking about her. It's like, ma'am, why do you even know this?
What is broadcasted live?
My hearings in regards to all of them, basically, but recently the stun cuff. Is there anyone that would know that I'm already wearing it if they could see it or not?
I can't speak to what everybody else knows.
So if I may, please, my options are pants,
So if I may,
hiding the
please,
stun cuff, or skirt, invisible, or I am able to sit here at the counsel's table with leg chains on, and no one is able to move except for here at the counsel's tables.
You certainly have the opportunity to stand, but we wouldn't be able to move around the courtroom, and those same restrictions would be placed upon the state.
Okay, I just wanted to confirm that those were my options.
Correct.
And when do I need to make that decision?
You don't have to make that decision today. It's something that we can address at the trial case management in September. Ms. Click, I see you raising your hand.
Your Honor, I just wanted to let you, so Ms. Boone is aware fully of what the options are with the county office for doing. I have gone through.
If you could, before you get to it, and just announce yourself for the record, please.
Very quickly, from the county office.
Yes, ma'am, go ahead.
We have gone through the entire clothing closet as well as our backup for what we have. As it stands right now, unless we have any donations to the size that have to match that size, we have 8 pairs of pants, 3 skirts, and 1 dress, and that is every, well, we do have shirts, but for in terms of skirts versus pants versus the dress, that is everything we have that would fit in this So I just wanted that to be aware so that if Ms. Boone is making any sort of decision, she understands the limitations in terms of what we have to be able to provide.
Okay. Ma'am, did you have the opportunity to hear what Ms. Glick said?
I did.
Do you have any questions for her?
If you could please repeat what it is that you all have available, the numbers.
8 years of pants, 3 skirts, 1 dress.
Ma'am, do you have any other
So they
questions
must
for
have
Ms.
some
Glick
sort of a
regarding the
clothing
clothing that the
closet
public defender is
available?
endeavoring to provide for you?
And if I do come to the decision, I can't always have someone externally bring something into me.
Absolutely, you can always have someone provide something in your personal property at the distribution center, which I described across the street from the center.
Sarah Boone is another one of these people like Wade Wilson who does have a certain amount of followers and a lot of interest in support. Like, girl, I'm not even going to talk about it, but she's got some supporters out here and she might have some people drop some clothes off to her. We saw Wade with all those suits during his trial. She might have some people drop her off some clothes.
That is not, the public defender's office is in no way involved with that. It was put in your property and the corrections with transport property.
Yes, ma'am. Thank you.
All right. Any other questions for her? All right. Can Ms. Glick be excused?
Yes, thank you.
Thank you, ma'am. The next issue that I wanted to address was the review of the digital discovery. Ma'am, Mr. Lane was provided at our last hearing on the 9th, the hard copies of the discovery, the USB jump drive, which contained the state's digital evidence, and digital transcripts of the depositions of detectives Chelsea Kopsel and Scott Lowen. And he was to meet with you on Saturday at 9 o'clock. Did that meeting take place?
Did
Okay, what was provided to you, if anything, at that meeting?
what he and I did.
What was provided to you? What was given to you by Investigator Lane?
The digital evidence we went over, and we're still reviewing the discovery, but I don't recall anything physically being handed to me.
Okay, all right. And when you say that you went over the digital evidence, are you referring to the USB drive with the 9 items that were identified in the state's exhibit list?
Yes, I do have that. We have not concluded going through that. We have other meetings tentatively scheduled, which we will be concluding that also in order to meet the deadline for the objections.
He wanted to know, do you have the jump drive from the state? She had 2 jump drives from her investigator who digitally processed her boxes of discovery. He just wanted to know, did you get the jump drive from the state? What did you get? Yes, we have it. We're reviewing it digitally, but we have not reviewed. He wanted to know, did you get the evidence from the state? That's what he wanted to know.
Of the 23rd of August.
How many of those 9 items were you able to review with Mr. Lane on Saturday?
Not more than 1.
Okay. Were you able to access all of the 9 items on that USB drive?
For the brief moment that he and I were able to attempt to do so, yes, they seem to work.
Okay, you did not have any issues opening up any of those files?
I personally myself did not open all of them.
Okay, all right. Okay.
It's on our to-do list.
Ma'am.
Girl, you are fighting for your life. What was the date of that? You had an appointment with Mr. Lane on what day? And he went over everything with you on what day? And now it is days later and you are sitting up here. See, you see how they're being patient with her because the state, they're doing their thing, but the judge has to kind of meticulously document her because what in between, so she can't come back and say, I haven't had time, because there's going to be times where she had time and she did not use the time. Or you had an opportunity before this meeting and we needed you to look at that. Like, he's documenting everything. So even though it might seem painstakingly like this is a lot, they're doing it to document, because this is a woman who's going to come back if she's convicted and say, I wasn't treated fairly. I wasn't given this. I wasn't given that. They didn't give me a chance. He's documenting everything.
Mr. Lane also took possession of the hard copies. Have those been provided to you?
They were waiting at the dorm for me upon my return of the last hearing.
Okay, and where are they currently?
They're located at my bunk area.
Okay, and what are they stored, or how are they stored?
The hard copies you're referring to?
Yes, ma'am.
The 2 boxes are at my bunk on the side in between other bunks.
Okay, all right. Are they in some type of bag, or is it just the 2 boxes that are right there?
Just the 2 boxes.
Okay, all right. Do you understand that, you've told me that you live in the,
Yeah, I think she'll be I mean, look, she killed George Torres. She's directly responsible, but I mean, due process and all of the things she gets but we know Kathy, like, girl, sis better make herself comfortable. It's going to be a long ride. I think the judge is trying to make sure that in appeal or any type of anything that he has crossed all T's and, because I think she's going to say that she was not given an opportunity to have an appropriate defense and she was given more. That's why he did the 16-page motion when he said the state is no longer going to pay and stressed you can still have a lawyer, you just need to pay for it or you are going to represent yourself. So
female dormitory with limited privacy. You understand by keeping those boxes there may be a risk as to other persons looking at them.
I don't have any other choice.
Okay, but do you understand that that risk exists?
Of course.
Okay. Do you understand that there's a risk that those items could disappear?
I understand.
Okay. All right. And do you understand that it's your request and choice to keep those documents in your possession?
I do. And I'm also requesting in my letter to the captain and to the major to also be able to store all of the USB drives and the hard drive in my locked drawer also for an extra security measure.
Okay. All right. I see that we'd have Investigator Lane here. Sir, if you can come out. Madam Clerk's going to go ahead and swear you in.
okay, after this next little part, Captain D. Giovanni from the jail is coming. This part is going to be good. But the guy who's getting ready to come up now, he is her hired investigator. He actually was working for her last lawyer, Patricia Cashman. And so he is a carryover from that last lawyer. And he's like her one valued asset right now that she better not run off or else she's just a complete certified fool. And he is doing his best to, he's not a lawyer, but he's helping her with her discovery. He's helping her catalog certain things. And he may end up doing some legwork. I'm not really sure, but he doesn't have a huge budget.
I do.
Sir, good afternoon. Could you state your name for the record and your affiliation with Prison Break Investigations?
Billy Lane, owner and chief investigator of Prison Break Investigations.
All right. Thank you, sir. I did see that your notice that you provided regarding the distribution or providing the discovery. You provided the hard copies and the USB with the digital and the USB with the depositions of the 2 detectives.
That's correct.
Okay. All right, sir. And when you met with Ms. Boone on Saturday, again, I don't want to go into any specifics, but were there any issues accessing any of those USB drives or any of the files?
Not at the progression in which we made through the files.
Okay.
I will be happy to let you know.
All right, very good. But as of right now, there's been no issues as to access from what you've reviewed. Okay, all right. State, do you have any questions for Mr. Lane?
No, Your Honor.
All right, ma'am, do you have any additional questions for Mr. Lane?
In regards to the drives,
Correct, based on what was teed up for hearing today, which was addressing your review of the USB jump drive, which contains the state's digital evidence.
Mr. Lane, are you able to briefly meet with me downstairs after this concludes?
I'm not sure if that's permissible with the policies and procedures. If not, I'm still trying to schedule a meeting with you.
Okay.
Any other questions for him, ma'am?
No, Your Honor.
All right, can he be released?
Yes.
All right, state.
Your Honor,
Thanks, sir. Appreciate you.
I think she loves that he asks questions like, are you okay with this person being released? Like, I think he's using psychology. He's giving her a little power on top of not getting much of her way. So you know what I'm saying? Like it
Okay.
gives her a little,
The
it
next,
gives her a little
ma'am,
feel
is
good.
your letter from August 7th
This is the
to
best
Captain
part, you
DiGiovanni,
guys.
which is the court has had the opportunity to read. I believe that we have a representative from the Orange County Jail who's appearing virtually. If you could please unmute yourself and turn on your camera, whoever it is that may be appearing from the Orange County Jail. I have a Administrative Sergeant De Jesus on the link.
Good afternoon, Judge. This is Captain Gina DiGiovanni with Orange County Corrections. I'm the captain of the Female Detention Center. And yes, I have Administrative Sergeant Stephanie De Jesus with me.
All right, very good.
I also want to make it clear that I have Orange County Corrections Department Legal Counsel Scott Chevenel on the phone with me.
Okay, very good. If all of you can, if the Captain DiGiovanni and Sergeant De Jesus, if you could please, I only see you, Captain. If Sergeant De Jesus can come into frame, we'll have Madam Clerk swear you in. If you both can raise your right hands.
Yes, ma'am. I do.
All right. Could you both state your names for the record for me again?
Administrative Sergeant Stephanie De Jesus.
Captain Gina DiGiovanni, Security Operations, Female Detention Center, Phoenix Facility, Genesis Facility.
And can I get appearances for legal counsel for the Department of Corrections, please?
Scott Chevenel, County Attorney's Office, representing the Department of Corrections.
Okay. All right. Very good. Captain, have you had the opportunity to review Ms. Boone's August 7th letter regarding some of the requests that she has in this case?
Yes, and if it's okay with you, Judge, I'd like to address each request one by one. Do you have a copy of the letter?
I do. And we can proceed with the 7.
Okay, number one, I love Captain DiGiovanni. I'm just gonna say, love her. Okay, that's on some tri-state area, right? Number two, last time we met, the letter that Sarah sent to Captain DiGiovanni, we read it. So go into the playlist. I think it's the last video. We read it. However, just know that Captain DiGiovanni is going to go through the whole thing and they're going to take it point by point. Okay. So you're not going to miss anything. If you're not familiar with the letter, Captain DiGiovanni is going to get into her requests specifically. But if you want to kind of just know what the letter stated top to bottom, then when we're finished with this, go to the playlist, the Sarah Boone playlist, and it's the last video. And we talked about it when it hit the website. Okay.
7 different items that she has requested. So if you
Actually, so with number one, the request to have her review time extended, I can make the extension in the following fashion. We'd still have to collect the laptop at 4 p.m. This gives the staff and supervisors the ability to conduct the afternoon head count, conduct the meal dinner service, conduct the shift change, and then the evening head count. I am willing to allow her Sunday through Thursday to get the laptop and the USB drives from 8 p.m. to 10 p.m. and Friday night and Saturday night from 8 p.m. to 11 p.m. That is more than the requested time that she has asked for additional viewing.
Ma'am, do you understand the extension that's being provided by the Orange County Jail regarding the laptop, that on Sundays through Thursdays, additional time from 8 p.m. to 10 p.m. and Fridays and Saturdays, 8 p.m. to 11 p.m.?
Correct, with them collecting it at the normal 4 p.m. time.
Correct.
Yes,
All right. Do you have any questions regarding that extension?
I do not,
Okay. Is that acceptable?
very much.
All right. Moving to the next issue, Captain, the USB drive security.
Number two, USB drives. It's a matter of security. The metal tips, the drive itself can be fashioned into something other than what it's originally intended for. These items are secured in a secure control room and inventoried by our supervisors on every single shift. They're also inventoried and acknowledged being in good working order and repair by my DSTs, the escorting officer, and my supervisors. So there's at this point, unless directed by legal counsel or consultation with legal counsel, I believe that these drives are secure and managed. This, by the way, is the same way it's managed by other facility captains, that you get a viewing period and then everything gets secured and inventoried.
Ma'am, do you have any questions with regard to the USB drive request in your letter and the position of corrections regarding it being a matter of security and how the USB drives are secured, controlled, inventoried, and confirmed to be in good working order?
I understand the process. My only concern is if I'm able to have my hard copy of 2 full boxes of my discovery, I'm not sure why, other than the fact that the assumption could be made that it could be made into something other than a USB drive. And I'm trying to avoid any further leaks of information that could possibly be suppressed or utilized in my case. So I didn't know if I could have my hard copies. I'm unclear, other than those reasons why I cannot have those as well.
To the extent you're able to answer that question.
I would just chip in that, obviously there's safety issues and you can definitely distinguish between, paper copies and anything made out of metal, which is what the captain just testified to. That's the problem, it sounds like to me, is anything that could be a safety hazard is an issue for us.
So, ma'am, do you have any other questions regarding the Corrections Department position with regard to the USB drives?
What was the outcome?
It sounds like unless I've missed something, it sounds like the Orange County Jail is going to continue with their protocol of storing, inventorying, and keeping the USB drives in accordance with the procedure as provided to you and read to you in open court.
And that's due to metal?
That's due to the reasons that were already identified. The matter of security regarding the drive being fashioned in a way that may affect security, and it continues to ensure that those drives are secured, controlled, inventoried, and in good working order. Would you have any questions?
Could you please provide the last name of Scott, the legal counselor, please?
I'll spell that, Judge. Shevvenell.
One more time, please.
Shevvenell.
Thank you.
With regard to the third request is to a classroom, Captain DiGiovanni.
So that classroom is a multi-purpose classroom. It's used by programs and chaplain services. I cannot allow the use of a classroom. What I can offer is, if the defendant is willing, I can move her to a housing unit and place her in a secure cell where no one will disturb her, and she can review and conduct case review. She will still have access to a shower. She will still have access to open day room time. She will still have access to phones, but the review and her location will be in a secured housing location where she would be the only person in the cell.
Ms. Boone?
Captain, is this Lima dorm?
K dorm.
Kilo. So my only options are being moved to the maximum security dorm or my bunk.
K dorm is no longer a maximum security. It's a multi-purpose area with inmates of varying needs being secured and housed there.
So it is not the maximum dorm any longer.
That's correct.
And I'm unable to utilize a classroom for an hour or two per day while it's dark the entire?
That's correct.
And if I may ask, other than it being accessed on a rare occasion of the 2 classes that do participate in that classroom, why is it that I'm unable to sit and be viewed by the officers at all times in my dorm comfortably to be able to utilize the phones on a regular basis, the day room on a regular basis, to be able to go outside to recreation, to have just for fresh air? How is that? I'm not understanding specifically why the reason is it has to be so extreme. From
Because
going
you're
to
in
being locked behind
jail.
a door 24
You're
hours a day
in jail.
to not being able to just utilize the classroom for an hour.
You tried to strangle somebody once upon a time. You have You have cycles. You have multiple cycles. Even though you have not been convicted of most of those cycles at this point, you've had run-ins. They've documented you. You've been difficult. They've had to manage you. You're somebody who everybody knows your name.
Hour or two per day.
Ma'am, you will still retain your rights as an inmate and have access to all the services and day room time that you currently have during the same operational hours. And instead of having to move items from a housing area into a classroom where the officer may have line of sight, I cannot guarantee that my officer will have continuous unfettered access to you to ensure the safety and security of that classroom while something may potentially occur in the housing unit. So as a matter of security to the rest of the inmates in the housing unit that you are currently assigned, my staff and the facility, I can make the accommodation where I could put you in a single person cell where you would have unfettered access, uninterrupted access to your case material, and still have my officers in the housing area where if you had a question or you wanted to take your shower during normal day room time, you would be able to do so.
I've been in a situation where I have been behind the closed doors also when I was made PC when I first got to Orange County Corrections Department. And if it's anything like that, I do not ever want to have that experience again. And to be honest with you, forgive me, Captain, but I do not believe that it would be this simplified. And nonetheless, I'm behind a closed door for 24 hours. Is there anything that I can do, any kind of research or further explanation in order for me to try to still be able to utilize my dorm, which is general population dorm, where I do have friends and I do have some type of comfort there.
Okay, this is the priority. She said, you want as much time? You've been there for 4 years, sis. None of these people are your friends. You've made friends with a bunch of people in jail. You are fighting for your life, potentially. Well, not even, yeah, she is, period. I don't know that she's up for a death sentence or anything like that, but sis, you're fighting for your life. You're concerned about a bunch of broads you met at the jailhouse. You better take your 2 months of peace and tranquility by yourself and unlimited computer time to be able to build your case. But you want to be able to sit and style hair and complain about the internet in court? See, that's why all of this is being documented. The judge is probably like, let her keep talking. Let her keep talking.
In order for me to be able to access the classroom, or simply are my options from working on my bunk or to the extreme of being behind a closed door for 24 hours? Captain?
Judge, I'm going to object to that question. It calls for her to speculate at this point as to what all the other alternatives may be. She's simply here to, responding as to this particular request, and now she's asking her this kind of this broad, general question about alternatives.
The objection is sustained.
In regards to number 4, earphones or headphones,
Let me say something from the last hearing. I would say it was funny, but this proves that Karen, Lambo Hush, she said, Judge, this might be a lame question, but what does sustained mean? Going back on silent, Lambo's vocal right now.
I would need to consult with legal because I don't know what the ramifications of that is. We've not had a pro se inmate ask for earbuds or headphones. I would have to defer to legal counsel and my chain of command.
I would almost think it's another safety issue because if you can't hear someone coming, someone could be behind you. There could be a threatening situation. There could be a fire. There could be any number of situations as to the reason why they need to have your complete, like your ears need to be like nothing over your ears, because that could definitely be another safety issue. you know? So I don't think it's a good idea. Also, if it's not Bluetooth, also things can be fashioned, they can be stolen, it can be fashioned again into a weapon. So I'm sure that's gonna be a no.
And for guidance in that request. With regards to number 5, internet access. Again, we've not had a pro se inmate, or at least not one that I've been responsible for, request internet access without limits. So again, I need to refer to legal counsel and my chain of command to get guidance on that. Regarding number 6, a word program. We've not had a pro se inmate, again, myself, that requested access to a word program. I would need to consult counsel, legal counsel, and my chain of command for guidance before we can make a response. Number 7, telephone access. In her statement here, as you are aware, my dorm contains payphones only and are limited to only 15 minutes per call, which are collect. I need to be able to communicate on a regular, normal phone to make all necessary calls. Hold on, I'm turning the page. For my case to use in trial. I have no other way to contact anyone that is not collect, which incredibly, I believe that's diminishes. I don't know what the other word is here. If not all of my opportunities to properly prepare. The phone system that we currently have in the jail for the inmates to access is as is. I don't have the ability to make any modifications. Number 8, discovery hard copies. It seems that Ms. Boone already has access to her hard copies. The concern I have to do now is do some research with legal and my chain of command, because that quantity of paper can potentially become a fire hazard. And we have standards in place. And Judge, I'm not certain if you're familiar with the Florida Model Jail standards, but the quantity of paper is actually the problem. So we may have to come back to the table for a different type of resolution regarding the 2 cases of paper discovery.
All right. Ma'am, do you have any questions regarding Captain Giovanni's and the Orange County Jail's position with regard to the earphones, headphones, internet usage, word processor, telephone, and the concern regarding the hard copies and it being a fire hazard?
I do, and I was also including number 3, the classroom utilization. I just want to make it clear and in open court that I want to have the understanding with everyone that it is an option of mine to decide to remain on my bunk with this discovery in the laptop, and it is or my option to be moved, but I have the ability to make that decision.
Judge, I have no objection to that. I am not looking to impede anybody's ability to access to a general population housing unit. I was simply offering an option that would be amenable to security and potentially Ms. Boone.
Okay. Am I able to proceed?
You can.
So for my understanding right now, you need to speak to your legal counselor in regards to the headphones, the internet, the Word program, and the discovery hard copies, which I already have. Is that correct?
And telephone access.
Oh.
You want unfettered telephone access, if I read your letter correctly.
Reasonably, I would like to have access to a regular phone. It could be 1, maybe 2 times a week where I save all of my calls for a particular day. I'm always up for solutions, just whatever it is that I can do in order to progress properly and expeditiously. I'm trying.
This is my thing too, and anyone could say I'm wrong. I don't know any legal folk in the midst. because you have people who, so because there's a certain protocol for one, then there's one for all. Sarah is getting some special privilege, but she also does have she is pro se, so they are accommodating her to a certain degree. But to the extent that you think you can have a phone, it's like it's one of those, if you do it for one, you have to do it for all. And maybe not everybody in the dorm, but then the next pro se is going to say, well, Sarah Boone got a phone, I want a phone. Sarah Boone got this, I need this. And then you have people who want to sue the jail. So you're going to hear in just a second. I don't think any of those things she asked for, I don't know if they have a law library, but she should be able to go to the law library and be able to maybe use their version of the internet. Maybe they have a limited internet functionality. As far as Word, you don't need Word. Maybe you can get notes, something like that, like a limited, what is that thing that's in your computer? If you don't have Microsoft Office, there's like a very limited little kind of word processing, very like ultralight type of program where you can, but I don't see her as being super computer savvy prior to her being arrested. I don't know. Maybe I'm wrong. Anyway, I don't like her getting internet, phone, word processor. I forgot what the other thing was, and a classroom. Those are all, notepad. Those are all like, no, like, you know what I'm saying, sis? Some people did it all with a legal pad and a pen. Like, your accommodation is getting paper and pens. You don't get to have, the only reason why she has a laptop right now is because her evidence had to be digital due to security purposes. And then she ended up getting the paper anyway. That's the only reason why she has a laptop.
To do so by having this, where I am confused why this was not all solidified prior to the implementation of the laptop. So I'm waiting for whatever it is that I can do to fully access and become a pro se defendant and inmate. Do you know when, how long the deadline might be for the open-ended items that I would be waiting for?
Judge, this is Scott. I mean, I'll chip in with the legal piece. The legal piece of it is simply that she's a pro se inmate. She's not the first pro se inmate that the jail has had. We've had several. And the issue is whether or not there's any constitutional or statutory violation with what we provide pro se inmates. And I would argue that there's not. She has access to the court as required by the law. Everything she wants is over and above what our typical stance is for pro se inmates, and all those policies are in place for a reason. But somehow she wants to go beyond that, and she wants all this extra consideration, more than anybody has ever been given, frankly. And at the end of the day, again, it's a constitutional question. Is it a violation of her constitutional rights, the restrictions we have in place? And I would tell you it's not.
Is that a position, Counselor, that you're taking today? Because Captain DiGiovanni had stated she needed to consult with legal counsel as to the issues of the headphones, internet, word processing, telephone issues. Is that the position that you're taking today, or is that something you need to further investigate to have a final position as to that?
No, that's my piece of it from the legal end. Now, of course, she's got to talk to her folks as far as the security end of it, because a lot of those things are in place because of security concerns. But from a legal concern, I can easily answer that today. And the answer again is, she's legally she's allowed access to the court and all these other things that she wants. And really, and I'll tell you what the case law says. The case law says if she's pro se, she's entitled to get, a paper, a pencil, and some stamps and some envelopes and those types of things. The idea that she wants unfettered access with the phone and she wants to make calls all day and night. At the end of the day, I'll also say there's case law out there that says, she's gone through, I think, 8 attorneys in this case, and she had several attorneys appointed to her case, and she's kind of put herself in this position today. And the case law is not real favorable to folks that put themselves in that position.
Ma'am, do you have any other argument with regard?
And oops. That's on some, and oops. Okay. Sarah. And oops.
To these requests as to the headphones, internet, word processor, or telephone?
So my understanding is that I'm being penalized by Orange County Corrections Department because of their misunderstanding in regards to my, in quotes, 8 attorneys prior. Is that why I'm unable to have anything in order for myself to properly represent myself as a pro se defendant and inmate of the Orange County Corrections Department?
I'm not going to answer that.
Not being penalized, just the opposite. She's being treated like every other pro se inmate in the institution. She's not being penalized at all. She wants consideration over and above what everybody else has.
If I may please, what is over and above? What other pro se inmates, what is it that they've asked for? I don't see how they could successfully even represent themselves without internet and a regular working phone. And I'm pretty sure that they were not able to complete their case in the successful outcome that they were hoping for by being provided simply papers and pens.
Counselor, if you.
I'm not sure if she's asking me a question. I don't know if I'm a witness in this case or if she's trying to ask me a question.
I'm not, you're just simply the attorney for
Right.
one of the participants, sir. If you don't, you're under no obligation to answer that question. You are just providing your legal position with regard to the Ms. Boone's demands and requests.
This is what I say, Sarah. Take it to the Supreme Court. Look, this is the motion. You are going to file a grievance with the state that in 2024, a pro se inmate needs more than a legal pad and a pen. That in 2024, a pro se inmate might need electronics. That is not the judges. That is not this judge's battle. That is your battle with the Florida Department of Corrections, Orlando jail. Okay. So you can sue them and say that constitutionally, when that was allocated to pro se inmates, that was before computers and PCs and tablets and all of those things. And you need that the Department of Corrections gets with the times and updates the materials that a pro se inmate can have. But that's not for today. You're not going to be able to do anything like that. That's not this judge's wheelhouse. And this particular attorney does not seem to have the energy to want to deal with you other than on some legal pad and a pen. You're getting more than enough, in his opinion, and there's no wiggle room. Constitutionally, you are not being impeded by the Constitution as a defendant in their jailhouse, and they are not compelled to give you more than what is allowable and that their security can support. And she doesn't, and then so she immediately goes to, so I'm being penalized because of my previous 8 attorneys and this, that, and like, she's such a victim.
They're simply requests. And I'm not sure who it might be that could answer my question, please, in regards to what prior or present other pro se defendants and inmates have requested. So I might have a guideline of something to go with forward. And I, again, do not know what is above and beyond simply asking for more than paper and pens in order to properly and rightfully and lawfully represent myself.
Counselor, to the extent you want to respond to that, you can.
Yeah, I mean, Judge, like I said, we've got tons of pro se inmates that have come through. They're there right now that have come through the jail, and they get standard treatment. And she wants a lot of things that are over and above that. For instance, again, unfettered phone calls. She wants to keep things in her cell that she can't normally keep, that they wouldn't allow folks to keep. So there's a lot of issues. I mean, that's a wide open question. But can I speak to everything that everybody's got in the past? How many pro se inmates we've had that have come through the institution? No, but I can tell you that we could probably find plenty of examples if need be as to what people have received in the past, and it's nothing close to what she's requiring or requesting today.
Okay. Ma'am, with regard to your state, do you have any position with regard to any of these matters we've addressed? Okay, thank you. All right, ma'am. So with regard to your request.
The state's like, I'm staying out of it because they're not the state. The state's prosecuting the case. But in terms of the accommodation that the sheriff's department, the state of the Orange County Department of Corrections provides, they're their own entire entity, and the state obviously is like, I'm out of it. The bottom line is they can only accommodate what they can accommodate. Not to mention they are accommodating more than what the Constitution has allowed, which to me, I almost feel like she shouldn't, if she shouldn't be getting, if she needs to have access to her evidence, obviously they're accommodating that, but they're accommodating it within the spirit of she needs her evidence. But as far as giving people basically like an office setup, no, you don't get an office setup. You don't get that. And also, if you do it for one, you got someone down the hall who hears about it, who's now pro se, and they want the same accommodation, and you're not giving them accommodation, and maybe they're Black, maybe they're Latino, they are Asian, and they feel like they are now being discriminated against. They're not getting the same thing that a white inmate is getting because they might be of another race. Girl, it's all kinds of implications there. They shouldn't touch it with a 10-foot pole. They should not touch it, because if you do it for one, you got to do it for all. Okay? Just like if you say you want a special diet, anybody can go in there and say, I want a special diet. I'm vegan now. And they're going to accommodate you, right? Because that's something that's now like dietary. They're going to do the best that they can to give you what you need within a certain guideline. Having a phone, having internet, that is not part of that. That's not something that they provide. And if they do it for her, then they'll have to do it for the next pro se inmate. And then they'll have to consider it for the next person who feels like they have to do extra research. And then it's like, okay, there's internet in the, I mean, some jails probably have it, but this one just does not.
As to the laptop, this jail will be able to accommodate your request, and those extensions will be provided as placed previously on the record. With regard to your request to hold the USB drives in your own personal lockup, for the reasons identified by counsel Chevenel, it's a matter of security, and the protocol which secures, controls, inventories, and ensures in good working order the USB drives will be complied with, so that request will not be accommodated. Your request for a classroom similarly cannot be accommodated for the reasons identified by Captain DiGiovanni on the record. However, there is an alternative housing offer that can be provided for you. With regard to your request for headphones, that has been rejected and denied by virtue of legal counsel's argument and what is being provided to you. With regard to the internet, word processor, and telephone, again, for the reasons that counsel for Orange County has identified, those cannot be provided to you. The court does note that you do have the services of an investigator, and JAC provided you $10,000 and $1,000 for travel for your investigator. To the extent as requested for the purposes of internet for locating witnesses and experts, you have a personal private investigator that can utilize, he could do that for you. I know you've made requests previously to look at your phone to find contacts and information. You also have a private investigator who would accomplish some of those tasks for you. And those can be communications and conversations between yourself and your investigator as to who and when and where and what persons you might be able to seek to find. So for those reasons regarding the headphones, internet, word processor, and telephone, based on arguments of counsel for Orange County, I'm unable to accommodate those requests. The jail is unable to accommodate those requests. Those requests will not be provided. With regard to the hard copies, that's going to have to be a matter, if it needs to be addressed, it can be readdressed with regard to the potential fire hazard. Captain DiGiovanni, would that still be an issue with regard to the fire hazard based on the amount of paper if Ms. Boone elected to move to the secured housing in the K dormitory?
Yeah, it's basically the Florida Model Jail Standard 7.12. The officer in charge or designee shall determine what personal items may be kept in the cell or stored with the inmate. However, an inmate shall be allowed to retain a reasonable amount of personal property, including but not limited to his or her legal material, personal hygiene items, writing paper, and writing instrument, and authorized reading materials in reasonable quantities as approved by the officer in charge or designee. Personal items will be kept in an orderly manner. Fire potential is reduced by limiting the amount of personal property in the cells. So it is the sheer volume of paper, and that is what I need to conduct an evaluation from. Now, in Ms. Boone's letter, if you give me one moment.
So if somebody decided they wanted to do like a jail takeover, which we've seen those happen, right? If somebody decided Boone has those 2 boxes of paper over there, someone could decide to set her boxes of evidence on fire because they're trying to disrupt the jail. They might want to take out a guard. Somebody might just be nuts. We've seen there's jail fires all the time. And somebody with 2 boxes of paper under their bed or wherever she's keeping it, that's a risk. Because if you're limited to 1 pad of paper, you're not going to set the dorm down. But if you have damn 2 boxes of paper and they decide to have, they decide to have some fun with you one day, they don't like you, you're in court, they decide to go through all your papers and you come back and you're mad, your evidence is gone, your stuff's been flushed down the toilet or used for paper airplanes, like, girl, it's a problem.
In number 8, discovery hard copies, she writes the following: as I am presently, I can keep these in the permitted property bag discreetly located at my bunk. I will purge the documents I have now and keep only new discovery hard copies. The remaining I can send to the property department and will purge anything already being stored for easy convenience and extra space. I'm willing.
You know what? I'm going to say this too. Last thing. This chick has been there too long. She's like, to me, she's already institutionalized. She has made Orange County Jail her home. She knows way too much about, I'll send it to property. I can do this. I can do that. Like, this lady knows her way around this damn jail. Okay. How will she light a fire? I don't know, but there's ways that inmates start fires. They do it as distractions to attack guards and things like that. I don't know, sis. Like, somehow they could steal a lighter from someone. Someone makes a mistake. Someone's caught slipping. Someone brings something in. You know what I mean? Like, I don't really know, but we do know that fires in jails happen and they're set by inmates because for whatever reason. So that's the fire hazard.
Willing to see what she's going to purge and send to property, but at the end, I have to reduce any fire liability to the building in order to maintain security and safety for the 399 other inmates that I have here, along with the almost 100 or so assigned staff, civilian and certified. I will also say that pro se inmates in the past have been afforded a second fire retardant property bag, and I'm willing to issue a second fire retardant property bag to accommodate the excess, but anything over and above that, we may have to find an accommodation. And based on the willingness of the letter that Ms. Boone has written, she articulates clearly that she's willing to purge and send to property any paper that's over and above.
Do you have any questions?
And
Well, no, go ahead.
and I
I'm
can
sorry.
have that second property bag upon her return this evening.
Ma'am, do you understand the second fire retardant bag that could be provided to you regarding the hard copies of the discovery?
I do, and it was already provided to me, but the boxes unfortunately do not fit in the bag, where I did attempt numerous times and even had others try to help me put it in the bag. I also did not know that they were fire retardant bags. I have the one already at my bunk, and I'm in the process of trying to figure out what needs to be purged. I also have my second family law case that I'm trying to be able to obtain those copies at my bunk as well, because of the difficulties of receiving and delivering anything to the property department, which is why I came up with the solution of me trying to purge what I can specifically to be specifically removed from the jail completely by a friend who can come and pick that up. I was just waiting.
So her second case that she's dealing with right now is a family law case. And it's not because she wants visitation. She's not asking her husband, her ex-husband, to bring the boy to come see her. She's mad because her alimony, I guess she was getting alimony or child support. I mean, maybe it wasn't alimony, but she was getting some sort of a spousal support check because they had 50-50 custody and her ex-husband was giving her a certain amount of money per month. That money has stopped. I think she was getting it for a period of time, but it has stopped and he's refusing to pay it. And she wants to waste time taking him to court. Meanwhile, you have a second-degree murder charge. Like, the woman is a buffoon.
Waiting for this hearing to happen so I can figure out when to tell her to come to do so.
So is that accommodation acceptable?
It is. I returned the second fire retardant bag, property bag, because I didn't want to have anything extra on top of my extra already. And it is not able to be used for anything that I can put in there where I already have everything in the boxes in the one bag already being occupied.
Are you satisfied then with regard to the treatment, for lack of a better word, of the hard copies?
What do you mean by that?
Sure. Are you, the procedure for having them stored and where they're kept is identified today? Is that acceptable to you?
Meaning I can have them where I have them now?
That's my understanding.
I think they were living off her spousal support check, which according to her ex-husband, she wasn't even a reliable co-parent. And they were both on unemployment. George had been fired from Ace Hardware and Sarah was laid off. And keep in mind, this was 2020. So it was the beginning of the pandemic. So she was getting unemployment checks. And I don't know if the supplement had started yet. Because I think when this happened, this was like March 2020, April 2020, if I'm not mistaken. So they would have been under COVID protection for their housing. She was getting, they were both unemployed and drinking all day and drunk and calling the police constantly. So it was a shit show mess over there. So yeah, go back in time to 2020 and that's when this was all going down. So this was a unemployment situation, supplemented check by the husband, unreliable co-parent. She's the type of chick that doesn't show up for the kid on time and may show up drunk.
Judge, may I say something here?
Sure. Treatment, for lack of a better word, of the hard copies.
What do you mean by that?
Sure. Are you, the procedure for having them stored and where they're kept is identified today? Is that acceptable to you?
Meaning I can have them where I have them now?
That's my understanding.
Judge, may I say something here?
Sure.
Okay, and thank you for allowing me the interruption. The cardboard boxes are not authorized by the fire marshal. The fire retardant bags are. So the documents are going to have to come out of the cardboard box and into the fire retardant bags.
Ms. Boone?
I would have to figure that out for the voluminous amount of paperwork that are contained in those two boxes. And there is no way to organize or separate. So it would just be a large mass amount of papers. So if I may, in the meantime, try to come up with some type of organizational structure of those two fire retardant bags with my hard copy discovery enclosed.
That is not the jail's problem. You actually, like, she's so dumb. That's not the jail's problem. You have two jump drives with everything electronically digitized and posted for you in a computer. But she wants the hard copy paper. And I get it. But at the end of the day, you have it on your computer and you can look through it a lot faster. I don't really believe she's as computer literate as she, fashions herself to be. I don't really think that I don't think she gets it. And she's been on pause technologically for the past 4 years. And she is, like I don't really think she understands. Like, you have everything digital. Nobody would be looking through 2 boxes of paper right now unless you really needed to see something. If everything has been scanned well, you should be able to see everything, if not better, on the computer. And roughly, she has about 10 to 12 hours. Well, I don't know, maybe 10 hours of work a day that she's able to work with her computer. She's stupid. She's worried about the wrong thing. She really is. It's unfortunate for her, but she's going to end up spending the rest of her life in jail.
In those, if I could please do so.
Mr. Chevronell,
She going to be mad.
Captain Giovanni, is there any way we can give her an additional bag or so and she can switch it in and out of property or whatever it may be? Can we provide her an additional bag that may help her to separate her documents?
I could provide the third fire retardant bag, but it's the encroachment into another inmate's area. It's a limited space. But the cardboard box can't remain. And Judge, if you recall my request, I had asked for all of this to be placed on a USB drive so that we would not have the paper in the jail for this very reason.
And I understand that. And Ms. Boone has continued to request the paper copies. And that's why everything was digitized, so that she would have that access to it. Everything has been digitized, but she has continued to request for those, and we're trying to make that accommodation for her as well. Yes.
Scott, if everything's digitized, why do we have to get the paper?
Because I don't think that she probably doesn't really know how to use the computer. The last hearing, it seemed like they may have had some zips or compressed files. And she says she was clicking on something and it made her click on something else and she wasn't really sure what to do. I'm like, they were probably some zips or something. And the guy was Detective Lane was just like, you just need to keep clicking and then you'll see the files. Some things are compressed and da-da-da. And she just seemed lost. This lady has been on pause with technology for 4 years. She probably doesn't know what she's doing. Lane had to come and sit with her to view the files because she couldn't open things. And she couldn't open things because she doesn't know what she's doing. That's why she wants the paper. Instead of saying, I'm not computer literate, I'm not up to date, I'm not current because I've been sitting here for 4 years. Why don't you just she's afraid to sound uninformed or ill-informed or not up to speed with everybody else. And you're not up to speed with everybody else. Just tell them you don't know how to use the computer.
That's up to her if she wants paper or not. That's fine.
All right.
It was never my decision to have anything digitized in the first place, and nonetheless,
it's like, shut up. They're giving you, she gets a win. The lawyer says, let her have the paper. And then she goes on. She doesn't know how to stop. Listen, she's going to keep going.
put on a laptop.
It wasn't
that is
my
not
fault.
even
I
fully
never asked it to be
accessible because some of the programs
digitized.
do not work, which I have not had the time yet to continue to go through everything that are on the USB drives. And that being not my decision.
And you know what? It's not sounding dumb. I mean, if you say, hey, you know what, Judge, I've been in here for 4 years. I haven't had my hands on a computer. I appreciate the fact that it's on a jump drive, but I don't even know what to do with this. I used to just get on Facebook before I got arrested. Like, you come off a little bit more intelligent, letting people know what your limitations are so somebody can actually help you. That's why Detective Lane had to go over there and help her. You pretending that you know what to do and you're arguing something that is not even current, that you want a box of damn paper, that sounds stupid.
Decision, and nonetheless, most important to me, they are limited and restricted to particular time periods. When those laptop times are closed for the day, I can therefore pick up the hard copy discovery, be it in a fire retardant bag or in a cardboard box or whatever else it is that I'm able to keep them there at my bunk. I have that.
It's like, Sarah, can you shut up? They already said you can have a third bag and you're good. You just can't keep the boxes. The paper goes in the bags. Be quiet.
As plan B when plan
But
A
she doesn't have a lawyer there to tell her to be quiet.
is closed.
Judge, if I might be able to offer a resolution here.
Okay.
Was the discovery that Miss Boone received, was it just a stack of papers in the box, or was there any type of manila envelope or filing separation system?
I haven't looked at them. I haven't copied them. They were opened in court back in, I think, June 28th, when we had the hearing where the court found that Ms. Boone had forfeited her right to court-appointed counsel and alternatively have waived that right by virtue of her conduct. I believe the box was open at that time, and there may be manila folders for some of the items, but I can't speak to all of it. I haven't reviewed it. I'm not able to review it.
Would Ms. Boone be able to indicate whether the paper is free-flowing paper, or was it bound in some way?
Ms. Cashman had represented that all staples had been removed and all paper clips had been removed. Ms. Boone,
It is a mass amount of paper.
are there dividers? Are there manila folders?
There, I believe, are 2 manila envelopes that have contents inside.
And everything else is just free paper?
As far as my understanding is, yes. I've not been able to fully dive into the boxes quite yet because of waiting for information for this. But I can further explore once I return back to the dorm.
I can provide some manila folders without any type of clasp or string in order to get the cardboard boxes out of the building.
I understand, and that would be appropriate. I don't know if I'm limited to a certain amount on top of the specified
God,
pen and
isn't she?
papers I'm
She's
able to have.
painful. It's painful, this woman.
My question
It's like, it's like that expression, you give an inch and they want a yard.
is, I would like to know also, please, for the reasonable quantities that you quoted earlier in regards to the amount of paper, is that the definition that you provided, is that for the enclosed housing area, or is this also for general population?
Ma'am, I'm responsible for the
It's like, Sarah, you said you don't want the private room, right? You don't want that cell. So why are you keep bringing it up? Do you see how she's so focused on the pain? She's so focused on what she doesn't want. She doesn't hear the win. They said you couldn't have paper. Now you can have paper. They said they're trying to get rid of the boxes and they're trying to give you files, but you still, like, now you're going back to, is this for the enclosed room? You said that you didn't want the enclosed room, so they're not entertaining that anymore. It's like she does have some intellectual deficit. Like, something is wrong with her. She does not pay attention. She doesn't pay attention. She doesn't understand. And what she does understand, she wants to argue that she, like, some lack of understanding. I don't like, she's really horrible, but they got the right judge. This guy is very patient with her.
based on the Florida model jail standards to reduce the amount of paper clutter.
You think George took off on his own? George was like, wait a
all
second, I'm
living
out of here.
spaces.
Aw.
It's not specific to just your housing unit.
Thank you.
Captain DiGiovanni, does that now can she switch out and get things out of the property within reason if there's additional documents in her property?
Through the request form, if she, we're going to authorize the second fire retardant bag. We're going to offer some manila envelopes without a metal clasp or string so that she could get everything into the fire retardant bags. And then we're going to remove the cardboard boxes, which are what becomes is the fire risk, because it is not authorized or recognized as a fire retardant item based on the fire marshal. The only thing that they consider fire retardant is the bag, and again, I will provide that. And then anything in excess, she could send to the property room. Well, and then upon her need for it, she could write a request to the property room, and the property room will bring it over. But she'll have to swap it out. I'm
Done.
amenable.
I'd be like, done,
I'm amenable
done and done.
to her keeping her documentation. I'm not looking to take anything away from her, but it has to be in accordance with, fire marshal and policy.
I understand. And I would be happy to comply with the extra bag and the manila envelopes for separators in regards to that.
So ma'am, if the jail was to provide you those manila folders for the hard copies and a third fire retardant bag, is that acceptable?
It is, if I do conclude that I need anything additional in order for them to be able to be held together in regards to some type of rubber band or some type.
No, that's a
something to be able to
choking.
bind the paperwork together. Is that a possibility?
She must not have seen anybody. Maybe they don't kill people in the Orange County jail. Maybe people don't get attacked and all those things like they do in other cities. But girl, don't you understand what could be done with a rubber band?
I didn't hear the question.
You may have to speak more clearly into the microphone in front of you, ma'am.
Would I be able to, please, if I needed to have a type of rubber band
Would I be able to please if I needed? Would I be able to please if I needed to be able to get some rubber bands, please?
or some kind of elastic in order to bind?
No.
Thank you. Just give her a summary no. Hail to the no.
And I know, Captain, that you are aware.
If
the
I
courtroom
could,
is not in
please, could I
regards
have
to
some
the,
rubber bands?
Property bags that you all do supply. There's no rigidity to them whatsoever. It's just a floppy bag. So when you pick that up, everything goes in the middle. So
If I were the judge, I'd be like, look, these items are things that you guys can discuss on the back end when you return back to your cell. In terms of the 8 action items, are we good here? The judge is really just letting them have a complete, it's like he's mediator right now, which is cool. That's what he's there for. But at the end of the day, at a certain point, it is time to say, that's not an item to be discussed in this hearing. You can talk about that when you get back to Orange County jail. These are the 8 items on the, as far as the rigidity and the quality and all of the things, it's like, come on, sis, what are you doing?
there's no type of, there's no way of actually being able to make sure that one pile stays in the one pile and so on and so forth. Do you have any suggestions other than manila folders that I might be able to utilize in order to keep those together?
The purpose of the manila envelopes is that you would put the paper in the manila envelope and that manila envelope keep the paper in order.
Okay, so they're envelopes, not folders.
Correct.
Thank you.
Ma'am, is that acceptable to you? And is there anything else we need to address with regard to the hard copies?
Not in regards to the hard copies, no.
Okay, all right. Is there anything else, ma'am, that we need to address today, Ms. Boone?
Yes, please, if I may conclude with the remaining amount of questions that I have in regards to my requests.
Sure.
Is it Mr. Shebamel?
Yes.
Could you please provide me with the protocol or policy that you all have, a guideline for me to follow, please, in regards to what previous pro se inmates may have had access to and be able to utilize? Do you have anything in writing as a hard copy?
No.
We'll have to check on that. You asked for, are you making a public records request?
I'm sorry?
Are you making a public records request?
I'm unclear of your question. I was just asking if Orange County Corrections Department had any type of guideline that you are accusing me of going above and beyond, other than the pen and paper. So I didn't know if you had a policy or process.
She doesn't know how to build bridges. This woman spent no time in corporate America. I don't know what her profession was prior to. I don't know I don't know what was going on. But this woman knows how to set a fucking bridge on fire. She doesn't know how to create pathways. She is always trying to take and tear down. Like, you asked a stupid question, then furthermore, now you are rehashing, tearing off the scab. It's like, this is what happened to George. There was no peace. There's no peace with her. You see this?
And if you have a pro se packet, like JAC has a pro se packet, does Orange County provide something like that?
You have to ask the jail that question. I don't know. I advise from a legal standpoint, and I can certainly tell the jail what the legal standard is. I'm not going to advise you as to what the law is, but I'll certainly advise the jail as to what the legal standard is.
Yes, please. Captain, I would be responding to you in regards to that or following up with you, or Sergeant DeJesus.
Ma'am, we don't have any access to that. I don't know anything about what other inmates that are currently pro se get other than that laptop. And the information transferred to a USB drive.
Yes, ma'am. Thank you. And Mr. Shabamel, you repeated that I have access to the court. Could you please define to me what your access to the court is for me?
Yeah, I'm going to object. I'm not a witness in this case. I'm really counsel for the jail, so it's really not appropriate to ask me questions. I know I've entertained a few, but I'm really not required to answer any.
Ma'am, he's
Okay.
not in a position to answer
Period.
those questions.
Yeah.
Could you please answer who might be able to? Because I am in desperate need to view the case docket, which requires internet, and I am still waiting for any documents that you have mailed to me. I am unprepared, it seems, every single time now sitting here at the counselor's table with not the same information and opportunity and advantage as everyone else in the courtroom because I'm waiting for the mail. So I didn't know if anyone had any other suggestion of how I might be able to receive those.
No, they're not giving
more
you a call. You got to get in touch with JAC.
Timely fashion, so I can be prepared in order to properly defend myself in apparently more than one way. Or every time that I'm here in the courtroom and something new is presented to me as a surprise. So I'm just trying to avoid those.
Items will continue to be mailed mailed to you at the appropriate address as required by the rules of judicial administration and general practice.
So if I may please clarify, my understanding is the only way that I can receive anything is through United States Postal Service.
I'm not going to answer that question because that would be me potentially providing you legal advice. But what I can tell you is that items will still continue to be mailed to you as required by those rules.
If I may please just make sure that everyone is aware that I cannot be properly prepared, as you can see now and prior. I just want to make sure that everyone is aware and understands that.
Ma'am, for the
That is not their problem to solve. That's not their problem to solve, sis. If you're not properly prepared, that's not their problem. That's not their problem at all. That's not their problem to solve. It's not their problem to even be aware of. And also, I think a few more times, I think he needs to tell her that I'm going to need to reprimand you if you continue down this path. Like, we're not going to go here. Okay. I need you to stay focused on you and not what everybody else is doing. If we say no, then you can file it back in a motion. If it's denied, it's denied, it's denied. There's things that are not in my wheelhouse to give you. We can't give you legal advice, any of those things. And you not being prepared and you going on the record to say you're not prepared, but they're giving you everything to be prepared is not their problem. It became your problem when you ran off 8 lawyers. I love
reasons
him
that we've
too.
discussed previously, I
He's
understand that.
amazing.
You're entitled to that opinion as to your pro se representation of yourself. Anything else that we need to address today? Ma'am.
Yes, I have a motion that I would like to submit, please.
Okay. Is there anything else that the jail needs to participate in with regard to this hearing?
Captain, would I be following up with you, or who would I be speaking to when I return to the dorm?
In regards to what?
I'm wondering in regards to the guideline and when and how the discovery hard copies, will the property bags be waiting for me when I return?
I will
She
take
said
care of that with my supervisors that are on shift.
Yes.
We will need the cardboard box so that we can dispose of that properly.
Yes, ma'am. And if I may, do you know why it was not approved prior when a supervisor was the one who delivered it to me?
I have no information about even the amount of hard copies. I didn't even know that that came into the jail because my conversation has always been that everything would be digitized and that we would have no hard copies so I could be in compliance with the Florida Model Jail Standards, Orange County Fire Marshal, and our policies and procedures regarding excess amount of paper.
Yes, ma'am, I understand. Thank you very much for your time. And Sergeant DeJesus and Mr. Shabamel.
Okay, are they free to leave?
Yes, thank you.
State. All right, thank you all very much. Ma'am, you made reference to another motion or something else that you had.
Yes, I have a motion.
Okay, if you can hand it to the deputy behind you. Actually, deputy, can you hand it to the state? State, you can take a look at it and then I will.
I don't feel like they have filed that motion yet. I don't know what this.
Thanks. All right, ma'am, give me a moment.
The
to take a look
motion
at this.
intervened. We saw that one. I don't see the motion yet. The motion, I saw a motion, but that wasn't from her. Petition or motion for attorney's fees payment. Oh, is that the one that she asked for the neuropsychologist? The motion for payment for costs for appointing a neuropsychologist? Girl, bye. Is this her? I hereby certify the JAC. I don't know if that's from her or not. I don't think that motion has been filed yet. I mean, it's not up on the docket. Anyone who's keeping an eye on this, I'm not sure. I don't see it.
Court has been provided a motion for payment of costs and appointing a neuropsychologist to
Okay,
assist the
that's the
defendant in
one.
preparation of the defense. State, I don't think we can have a hearing on this without JICS.
State takes no position. We don't have anything to do with this.
Okay. Ma'am, I can't have a hearing on this today.
Mhm.
I will have to coordinate a hearing with regard with JACS to have this heard because this is something that involves them.
Correct.
And they haven't even had the opportunity to review it yet.
And they are copied on that as well.
I do see that, but you're hand filing it with me right now.
Correct. Thank you.
So the court will file this in the court file and we'll coordinate a hearing as soon as practical with regard to this motion, and it'll be heard before the end of this week. Anything else, ma'am?
Just to confirm, please, for the next deadline for my responsibility to meet would be the August 23rd for the objections to the state's USB drive that they provided.
As identified in the court's order, that is the deadline. The
Okay,
only
I
other
see it.
deadline, ma'am, is the September 3rd deadline for the viewing of the state's physical evidence, which sounds like that's something that may take place prior to that deadline. As you may recall, you will have 14 days after that evidence viewing to tender any of your objections in writing to the court, 14 days thereafter, and that will be extended for good cause shown. Anything else, state?
Nothing state.
Ma'am, anything else?
No, Your Honor.
All right, we'll return Ms. Boone back to the custody of the Orange County Jail, and we'll coordinate the hearing appropriately. Thank you
Girl,
very
go
much.
back to your cell.
Forgive me. In order possibly for a solution for me to know about the hearing, especially for the one regarding the JAC, is it possible for you please to relay it to Mr. Lane and he can tell me sooner than the mail?
I can certainly do that.
Going forward, so I would have some opportunity quicker than waiting for the mail.
I can certainly advise him of that, or my office can. Sure. Okay, I understand. All right, just so for recap purposes, with regard to
Look, Mr. Lane's look, he has a $10,000 budget that he can earn. So that's money that's already allocated for Mr. Lane. Mr. Lane runs his own business. Mr. Lane's probably like, sure, you want me to put an alert on the file so I can let you know when court like things are happening? Sure, why not? That's a billable moment. I mean, he can probably bill whatever he needs to bill for that. So yeah, he's going to collect all those monies, and when you run it out, then you're just going to be without. So you guys, I'll take a minute. We'll finish this up because we only have like 2 more minutes. I do have the letter pulled up in front of me, which she filed with the court. Hold on a second. But I have to finish dinner. I have to get this popping over here. I will read this. I'll take a minute, read it, and I will post this, or we can go over it tomorrow. So she asked for a neuropsychologist and she wanted money allocated for that. I do think that JAC is going to give her some money for the neuropsychologist. So let's break that down next time. Next time we meet, we'll talk about it. It was filed correspondence from the defendant. Hold on. Let me show you. This was what she gave the judge. Correspondence from defendant, motion for payment for costs for appointing a neuropsychologist. Then there's the response right here. The next day, she did get a response from JAC. So I have what Sarah mentioned in court, and I have the response. So if you want to know what the response was, come back to the next Sarah Boone Live and we will talk about it. Okay, guys. Let's get the last minute or two, and I'm gonna let y'all go because we've been here for a minute. Okay, Sarah is a she's a lot of work.
Is first addressed this afternoon. The court orders that the defendant has failed to meet the burden of producing evidence and proving by a greater weight of the evidence that closure is necessary as required by Miami Herald Publishing Co. versus Lewis, 426 Southern 2nd, 1 at pinpoint 8 by the Florida Supreme Court 1982. As such, the defendant's requested closure of the state's physical evidence viewing with the state and defendant set for September 3, 2024 at 9 a.m. is denied. With regard to the other items that were discussed today, defendant and state agreed to an alternative arrangement as placed on the record on August 14, 2024 regarding the viewing of the state's physical evidence as tendered in open court on August 9, 2024. The state shall prepare for all parties to execute a notice reflecting when the evidence viewing took place and the length of time that the evidence viewing took place. The state shall file with the court the executed notice after the viewing of the state's physical evidence takes place. Defendant's request regarding extending the laptop time has been agreed to by Orange County. The times have been extended as follows: Sunday through Thursday, 8 p.m. to 10 p.m., and Friday and Saturday, 8 p.m. to 11 p.m. This is in addition to the times outlined in the memorandum from the Orange County Corrections Department Security Operations, which was previously provided to Ms. Boone and read to Ms. Boone. Defendant's request regarding the discovery that was provided to the court on June 28, 2024, and keeping that discovery in defendant's possession was addressed to defendant's satisfaction on the record on August 14, 2024, and the balance of defendant's requests cannot be accommodated for the reasons placed on the record on August 14, 2024. Ms. Boone, you'll be given a hard copy or hand-delivered a copy of these orders momentarily.
Thank you.
All right. Anything else? Anything else, ma'am?
No, Your Honor.
All right. Thank you very much.
Thank you.
Okay, guys. So yeah, that's what's for dinner. I started dinner before I started this live, so it's been stewing. I just need to get the cornbread popping because it is 7 o'clock. So I need to get the cornbread going. I'm gonna make some basmati rice. I think I'm going to either saute spinach, which I love spinach, or green beans. I'm not sure. I'm gonna ask my husband which one he prefers. And then that's it. So that's what's for dinner. Nothing glamorous. This, what I'm saying? Like it's nothing amazing, just food. But it's good. I think it's going to be good. So I was considering cabbage too. Cabbage was on my mind, but I was like, you know what? I better stay back from the cabbage. I just ate some fish, Cajun cabbage, and sweet potato. I love sweet potato fries. Yum. You guys are awesome. I hope you enjoyed it. Sarah Boone trial is going to be pretty interesting for all of you court watchers. You're going to love it. Like, I think she gives everything that we need in a trial. Hey, Mocha. Hey, Boo. Anyway, let me let you guys go. Let me go ahead and finish up my dinner real quick so my husband can eat and handle his business because I know he's got to be hungry. Anyway, guys, I love you guys. This was so much fun. Hey, PW. Every time I see PW, I got to do this. PW, you already know what I'm getting ready to do. We made it. Girl. Okay. Sarah makes everybody want to have a drink, some coffee, something. Okay. All right, you guys. I hope you had a good. Check out Gossip, Rumor, and Innuendo tomorrow morning. She usually drops like 7 o'clock. Go check out our sis, and you guys have a good evening. If you're new here, I hope you enjoyed it. We're so happy that you came through. Make sure to subscribe to my channel. Hit the thumbs up for me because likes do matter. And if you have any friends who might be interested, they're court watchers. They like true crime. They like to gossip and throw shade while talking about what's going on. Share me out. Go ahead and share me. Share me out. Okay, guys. Have a good one. I will see you guys next time. Take care. Bye, Bougie Gang. Happy Sunday.